Hello everyone. Hope you all are doing good at home. I, Devendra Tiwari, Associate at Law Chamber of Siddharth Murarka, welcome all of you in today's session. Today we have speaker Mr. Naushad, engineer, practicing counsel at Bombay High Court, and today he will be enlightening us on today's topic, an overview on Rera. Before I begin, to request Naushad sir to enlighten us on today's topic, I'll request everyone to please switch off your mic and video so that we don't have any disturbance in hearing today's lecture. Now, I would like to request Naushad sir to begin his lecture.
All right, so should I start now?
Yes, sir.
Okay. Okay, first, let me start by thanking Mr. Murarka's Law Chambers and Devendra for organizing this and inviting me to speak today to all of y'all who have taken the time out, though I know you are my captive audience since we're all under lockdown, but still, thank you for attending this lecture. The topic that I'm basically going to be touching upon today is the Rera Act, which, as you all know, was enacted first on 1st of May 2016. I will essentially, during my talk, basically speak about why legislature felt the need for Rera. I will then basically be explaining what is the applicability, the objectives, and the salient features of Rera. And then 4 or 5 aspects that we frequently see are now going to come up in court, or issues that have come up and are still pending consideration in higher courts, and just my thoughts on those. But let me first start by, in that sense, explaining why was it felt that there was a need for having the Rera enactment, the regulatory authority. The Indian Brand Equity Foundation has on their website stated that the real estate industry in India is a $120 billion industry. It is an industry which, from the period 2000 to 2017, showed the highest rate of growth. It is estimated that by 2030, it is possible, with foreign direct investment coming in, that it might be a $1 trillion industry. There have been rates of growth of up to 30% that have been reported in a year. Though, of course, just now, there is also, especially in, say, Bombay or in Maharashtra, what they describe as a property bubble and a price bubble. Prices have come down substantially. And now, in view of this COVID-19, things might even get worse in that sense. But on the whole, if we consider the real estate industry, and even when we consider the figures as of 2017, 18, and up to 19 of $120 billion, it is indeed strange that right until 1st May 2017, there was no regulatory authority for monitoring this industry. There are various other industries which have regulatory authorities which were governing the functioning of the players in that particular sector. But finally, as of 1st May 17, the Rera Regulatory Authority, if I may call it that, in fact came into existence. So the reason why, it is important to note that it is in India today an aspirational goal of most of its people that they want to own a home. Though under our constitution, under Article 21, you'll find several judgments from Olga Tellis to P.S. Gupta in 1995, which said that shelter actually is a fundamental right. However, it is, and we all know it, it is a distant dream in that sense to say that everybody should have a roof over their head. Poverty is such, population is such that that's not yet been possible. But even for those who do have the means, and it's something that we all know, if today, especially in the metropolises like Bombay, Delhi, Calcutta, or Bangalore, if you want to buy a home, you virtually have to put in your life savings into the home, or you are taking a loan and mortgaging and having to repay that mortgage over the next 20 years or the better part of your adult life. When such a step is taken, it's always going to be in the hope that there should be no difficulties, there should be no hiccups, and the developer or the builder should give the flat as promised in the time promised. However, as most of us lawyers, especially practicing in Bombay, will know, that hardly is the case. More often than not, and there is a huge volume of litigation, whereby flat purchasers are constantly having to take the builders to court, seeking either performance or compensation or seeking compliances of various statutory formalities. We have seen cases where builders take monies from flat purchasers and have simply siphoned the monies away and disappeared, or monies are taken from a flat purchaser for a building in place A, and the money is used to actually complete an ongoing construction in place B, and the flat purchaser doesn't see the light of day for his own flat. Projects therefore get grossly delayed. Builders ultimately change layouts without consent. Pricing is vague and it was not actually being clearly indicated as to what were the various components. The areas also were different. If a builder told you that I'm selling you usable carpet area of say 1500 square feet, you didn't know actually what was the carpet area you were going to get. Amenities were regularly being changed, one-sided contracts, and there was no transparency. There was no way that you could actually ascertain what the builder was going to do. So this was, in that sense, the prevailing situation. And this was the situation despite the fact that there was a Contract Act, a Specific Relief Act, the MOFA Act, and the Consumer Protection Act, which were available to the flat purchasers, and which was, in that sense, the legal framework which was available. Despite this, one would see that there was such a huge amount of litigation on this point of view. The other aspect, of course, is especially in the cases where it's like, say, the Bombay High Court in its original jurisdiction, even if you were to file a suit, you wouldn't see light of day for at least 10 to 15 years. So when all of this was going on, it was felt that a regulator was needed. In fact, the Competition Commission, in a case of Bel Air Owners Association versus DLF, in August 12, 2011, held that there was in fact a need for having a real estate regulator who would be able to monitor the real estate industry. Of course, by this time, legislature had already started working on it. In 2013, in fact, the first draft came about. And ultimately, as we know, on 1st of May 2016, Rera came to be enacted. All the provisions in the initial stage were not brought into force, but by 1st of May 2017, all provisions in fact came into force. So the question therefore now really is what was the objective of Rera? And to understand the objective of Rera, I don't think that there's anything clearer than by reading the preamble of the Act. And if some of you all do have, or if you all have the Bare Act with you, I'd only just like to read this out. The preamble states that it is an act to establish the real estate regulatory authority for regulation and promotion of the real estate sector, and to ensure sale of plot, apartment or building, as the case may be, or sale of real estate project in an efficient and transparent manner, and to protect the interest of consumers in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal to hear appeals from the decisions, directions, or orders of the real estate regulatory authority and the adjudicating officer and for matters connected therewith or incidental thereto. So when we see the preamble of the Act, it starts off by pointing out that this Act has been established. It's an Act to establish the real estate regulatory authority, who would regulate and promote the real estate sector, which would then ensure the sale of plots in an efficient and transparent manner, and to protect the interest of the consumers. So if I may just in that sense sum it up, there are 4 real objectives. First is the setting up of the regulatory authority. 2 is to ensure the sale of apartments in a transparent manner. 3 is to protect the interest of the consumer. And 4 is to establish an adjudicatory mechanism, which includes the adjudicating authority as well as the appellate forum. So these really were the objectives of Rera. And the first thing, therefore, we need to see is that to what type of projects or what type of developments does Rera apply? Now, insofar as the applicability of the Act is concerned, it applies, as we can see from section 3, it applies to all development projects which were new, and it also applied to ongoing development projects which had not yet received their occupation certificate or completion certificate. Therefore, if a project was obviously to start, then there's no question that it was applicable. But even a project which was an ongoing project was governed or would be governed by Rera, it would be necessary to register the project. It would be necessary to then comply with even the requirements of the Act. It's also clear that it doesn't apply only to residential apartments. It's not only for residential or flats or for homes. When we see the definitions of building, it says that it applies for all real estate projects. Real estate projects are defined in section 2ZM, which talk about development of apartments or buildings. And if you see the definitions of apartment and building, apartment is in section 2E and building is in section 2J, it is clear that it applies for residential, commercial, shops, showrooms, and even godowns. So the applicability of the Act, therefore, is that it applies to development across the board, whether it be residential or commercial. And the Act then in section 3.2 draws as to what is exempted. Now, what is exempted is only this: where the development is going to be of a plot area less than 500 square meters, or where there would be less than 8 allottees, or where a project has already received its OC or completion certificate, or where the work which is being carried out is not for any fresh or new sale, but only a repair or a renovation in that sense of an existing building, where there would be no new sales and no new marketing and no new allottees would be buying the flat. It would only be given to the persons who are already in occupation or who are in the existing occupants of the building. So the idea was to get to make the applicability of the Act as wide as possible. There is, of course, one judgment in Techno Drive Engineers versus Renaissance Indus Infra, in which the Maharashtra Rera Authority has said that though the Act applies for residential and commercial, it doesn't apply to industrial projects. So where it is only a factory building which is being constructed, then it doesn't apply. Because they have sought to use the words when it says that residential, commercial, trade, profession, they say that all of this does not contemplate actual industrial activity, and where a company or an industry is constructing a factory for itself, then RERA would not apply, is what the authority has held. So that is insofar as the applicability of the Act. The persons who are governed by the Act are essentially three. One, of course, is the allottees. Two is the individual who is actually carrying out the construction, or on whose behalf it is being carried out, who is being termed as the promoter. And the third is the real estate agent. This again is something new in RERA. It was not something that was there under any of the earlier acts, which I had mentioned. And we'll touch upon that a little later in today's talk. But the real estate agents have also now, in that sense, sought to be regulated and is no longer in that sense an unorganized sector now. Now there are registrations that would apply to them. They have certain duties and responsibilities. And if they fail to comply with those duties and responsibilities, there would in fact also be a punishment that could be imposed upon them. So for all these development projects, whether you be in the real estate agent or the promoter or the allottee, you are now going to be governed. And the only exceptions are where the actual construction work which is to be done is on a plot less than 500 square meters, or where there would be less than 8 allottees, or where the project was already completed, or where it was only for repairs, renovations, and there was not going to be any fresh sale or new allottees in that sense who would be given the flats. So that covers, broadly speaking, the applicability of the Act. Now the main focus really is as to what are the salient features of the Act and how does the Act actually work. What are the advantages? In that sense, the Act seeks to achieve its objective really, which is to bring in accountability and transparency and to look after the interest of the flat purchasers. Now, the first aspect on this, and what is crucial, is that all new or ongoing projects had to be registered with the authority. This is set out in Section 4 of the Act. Now, it's obviously clear as to why this is being done, because when any promoter has to register the real estate project with the authority, he has to in fact set out what are the plans. Does he have an IOD, the title certificate, the draft allotment letters, the draft agreement that he is proposing to enter into, his layout plans, all permissions that he has at that point of time. All of that has to be registered with the authority so that there can be no doubt or confusion as to what is the representation that is going to be made to the individuals who come to purchase the flats. So these details have to be given, and there is a form which is required, which is a detailed form which is there, which is required to be filled up. And it is on that basis that if all of this is complied with, that the authority would then register the project and would give a registration number, which, as we've all seen today on various advertisements also, which are being given by the developers, you'll always have the RERA registration number, which has to be mentioned. So registration under Section 4 is something which is one of the main aspects in that sense of RERA, which is there to actually ensure that there is going to be accountability and transparency, and that the flat purchasers are not in that sense going to be taken for a ride because they are shown something in the beginning and then something else turns out and the builder says, oh, I had to change the plans, or this was a draft and this is the actual plan. So that all of that ambiguity is done away with, because the plans have to be given to the authority at the time of registration. So that really is the first point. The second point, sorry, am I audible? Hello?
Yes, sir, we can hear you.
Yes,
Okay,
yes.
okay, no, sorry. So so that's the first salient feature of the Act. The second salient feature that I would like to point out is as it, I mean, it's a corollary which really is that you have to, in fact, have all these documents which are being given. The third is that there can be no marketing, no selling or advertising of any project until the registration, in fact, has already been done. This is section 3 of the Act. Again, it goes to accountability and transparency. The idea, therefore, is that no developer can, without having these, if I may put it, the absolute, like that, the bedrock in that sense of the project already registered, actually start to advertise. Because a developer who even has a dishonest intention will need to advertise to attract flat purchasers to invest into the project. So therefore, they said that even before the developer starts doing this, we must make sure that he has already got himself registered. And to get himself registered, all these various documents must already be in place. In fact, there's an interesting case of Godrej Properties, where they had actually put up around about 30 hoardings in Thane, and they were advertising one of their developments over there, and they hadn't gotten themselves registered. Rera fined Godrej Properties 30 lakhs as the penalty for non-compliance with the requirements of registration. And the penalty is set out in section 59 of the Act, which actually can be up to 10% of the cost of construction of the project. So the penalties are not small penalties of 2,000, 5,000, 20,000 or a lakh. It's actually an ad valorem penalty, and it's a large sum of money. So this again, to my mind, is a very erudite step in that sense in ensuring that there is going to be a sense of clarity in the mind, or transparency, as it were, before any flat purchaser even looks at a project or looks at the brochures or looks at pamphlets, that he knows that it's been registered. He knows, therefore, now that the plans are there, the sanctions must be in place, and therefore it's got a registration number. The fourth aspect, which is again a very important feature of Rera, is Rera has now defined carpet area. And what is important is this, that when you read section 4 and you read it along with section 13.2 and the registration form, it clearly mentions that the actual carpet area as defined under Rera must be disclosed. So builders, when they were selling their properties, they would say, I'm giving you usable carpet area, built-up area. Every developer had a different loading factor for what he would consider to be a built-up area. Some builders were loading, I mean, as our Ready Recna also has it, it's about to convert from carpet area to built-up area, there was an addition of 20%. However, it's not unknown that builders are actually loading 30%, 40%. So even when a builder goes and says, I'm going to give you a built-up area of 1,500, your flat might actually only be 700 or 750 also. So now that is sought to be done away with, because the actual carpet area as defined under Rera, which now is in that sense the actual floor plate, including the internal walls, but it excludes the balcony, and balcony has to be separately disclosed. So that now has to be at the outset indicated as to what really is the carpet area that a flat purchaser is going to get. So he knows in that sense that though he is paying price X, he is going to get this actual area. So which again, to my mind, is a very important feature of the Act, which makes the disclosure of the carpet area mandatory. The fifth salient feature is the fact now that there has to be a separate account in which 70% of the amount collected from the flat purchasers must be deposited. And that money can only be used for construction. This is section 4.2 LD. Now, what the past, and I mean, especially as lawyers, for all of you all who are lawyers and who have probably handled some sort of property litigation for a flat purchaser or for a builder, or either which way, very often what was found was that builders were always in need of money because they were always taking financing. They were carrying out multiple projects, 3 projects, 4 projects, 8 projects, 10 projects at a time. And they would actually circulate the money. So if they were running short of a project which was, say, halfway done, and they launched a new project, the money that would have been obtained from the new flat purchase of the new project were actually being pumped into the existing project to carry that on. And they would say that, all right, fine, for the new project, still some time is there. We'll see for that money later. So what was therefore happening then is that at times when builders bit off more than they could chew, one project always got sacrificed. And the flat purchasers of one project were then left waiting for years on end until the builder could actually arrange funds, or sometimes the builder, in fact, would then basically become insolvent, and then there was nothing that could be done. These flat purchasers were basically unsecured creditors, and their life savings were simply wiped out. So to avoid this consequence, it was made clear now that 70% of the money that was collected from the flat purchasers had to be deposited in a designated Rera account, and that money could be used only for construction of that project. The section 4.2 LD in fact makes it further clear that even when the developer wanted to withdraw that money for using it for the purposes of construction, he couldn't just do it as per his whim and fancy. He needed to get an architect certificate, an engineer certificate, as well as a chartered accountant certificate to actually establish and satisfy the regulatory authority that he needed to withdraw this amount of money as the proportionate expense for the stage of construction which he was at. Without these certificates, he was not allowed to withdraw that money. Now, of course, I mean, in the sense that so far as the builders are concerned, they find this to be a terrible restriction. They find that it completely ties their hands down, and perhaps it does. But the idea and the aim of the legislature, and when we go back to the preamble, is this is an act really to protect the interest of the flat purchasers. And it is because of the amount of past litigation and past experience which the legislature noted that they realized that this was required. Even the manner of determining the cost in that sense is set out in Rule 5 of the rules. And therefore, this again ensures that the money that is put into the project is not siphoned away, is not taken away, and is actually being utilized for the purpose for which the flat purchaser gave it. The sixth salient feature is what I would call the end date, or the final date by which the project had to be completed in possession, handed over. The form requires the registration in that sense. Every developer must indicate at the time of registration up to what date the project would be completed by. Most builders, in fact, today in practice are, suppose even if they know that they could complete the construction, say by 2022, their Rera completion date will often be 2023 or maybe even 2024. They leave that little buffer because they now know that if they don't complete it, there are serious consequences. So the registration also carries an end date. They have to, in fact, complete it by that date. The legislature, of course, was conscious of the fact that there may be some circumstances in which it may not be possible, despite the developer's best efforts, for reasons completely beyond their control, that the registration could be extended. And that's in section 6 of the Rera Act. And it makes it clear that if they make out the sufficient cause, essentially has to be a force majeure condition, they can extend the period for up to a maximum of 1 year. After that, the registration in that sense couldn't be extended, it would lapse. So that is section 6. The other important feature, again, which goes to the fact of bringing accountability and transparency, is that the developers would have to be bound by permission, the amenities set out even in their brochure or their pamphlets or their advertising material. This is there in section 12 of the Act. There were many cases under MOFA where a developer would show certain types of amenities, but ultimately in their brochures and their pamphlets, but they didn't in fact provide those. And it was held that, well, a brochure is just an advertising material. It is essentially what was called fluff. It's in that sense to entice a flat purchaser to buy. But what was actually to be provided is only mentioned in the agreement, and therefore advertising material and brochures, etc., didn't have any binding value. Rera has, in that sense, tried to correct that. They have said in section 12 that all these representations, etc., that are required to be entered into have to be complied with and have to be followed. Despite section 12, I must point out that there is one judgment in the case of Anita Castellino versus Godrej Landmark, in which they have held that section 12 applies only till the agreement is entered into, and that once the agreement is entered into, then section 12 doesn't apply, and what the parties would be bound by is the agreement. And that to some extent makes sense, because, for example, if in the brochure it said that each flat was going to have its own jacuzzi and there would be a private garden along with each flat, but in the agreement, when we see the list of the amenities that are set out, if those are not there, and if the party consciously still signs that agreement, he then cannot go back to say, but under the brochure you said this, under the brochure you promised that, and therefore you must give it. On the ground basically of a substituted performance having been agreed to, that though it was there initially, you have now agreed to accept the flat even without it. You then can't go back under section 12 and say, no, but you still have to provide that to me because it was mentioned in the brochure. I believe this judgment is in appeal. I'm not sure really about what has happened in that. So, and on this, just one more point. In the Hiranandani matter, His Lordship's Justice Patel, when he heard the matter, there is a line in that judgment as well where he says that builders must be held to the representations made by them even at the time when they were, in that sense, advertising and giving out their brochures and pamphlets. That judgment was upheld even by the division bench, and ultimately even the SLP against it was dismissed. So that, of course, was under MOFA, but there are contrary views on that. But now, at least under section 12, it makes it clear that, I mean, even prior to the agreement being entered into, the parties, in that sense, the promoter cannot make a representation and advertisement and then have no intention of actually performing it. Next after this really is that no promoter, no developer can ask for more than 10% before the agreement for sale is actually signed and registered. Under MOFA, they couldn't ask for more than 20%. But now under Rera, it's 10%. And that's again in section 13 of the Act. And the added advantage under Rera, of course, is that under MOFA, even if the promoter did ask for more than 20%, you would have to file a suit, and that would take years. And therefore people, I mean, that though the provision was there, it wasn't really being actively enforced. Under Rera, because there is a regulator now, it is something which is capable of being enforced and is being enforced now. And this again ensures that it prevents double sales. Because earlier what would happen is the promoters often would maybe try and sell a flat to 2 people or 3 people, and no agreements were in that sense being actually executed. They were on allotment letters, on MOUs, the documents weren't being registered. So this cuts out with that and ensures, because what happens then is that if the document is registered, it becomes easy for any flat purchaser to go and take a search and actually figure out whether there is any sale with regard to that flat. The next feature that I would like to highlight on is again something which is important, is that the promoters have to give regular updates about the status of the construction. This is there in section 11(1) of the Act, which must be read with rules 20 and 21. 11(2) also requires that the Rera website address must also be mentioned on all the publicity material, advertisements, in all, in everything, so that the flat purchasers who would be interested in ascertaining what is the actual status of what is going on in the project can easily know where to look. This again, in the case of Piramal Realty, they had not put the Rera website address on some of their material, and the Rera in fact fined them 50 lakhs for not doing so. So again, the importance really of this is that not only is the registration required to be done at the outset, but even as and when the project is being carried out, they must regularly update and inform the authority, and by that way, even all the flat purchasers, that this is the stage we are at, this is how much has been completed, these are the permissions that we have obtained. The 10th aspect which I'd like to highlight on is for change of plans. Now, there are so many judgments, and I'm not getting into it now, under MOFA about change of layout, change of plan, section 7, 7A. And there was a huge body of law on what exactly could the promoter do, to what extent could he change. This has now been made a little clear, and any sort of ambiguity has now been done away with. And in fact, they've pointed out that if a promoter wishes to change the size, the layout of a particular apartment that has been sold to an individual on what this term is the allottee, he can only do so with the consent of the allottee. If a promoter wishes to change the layout, common amenities, facilities, he can only do so with the consent of 2/3 of the allottees. This is set out in section 14. But with 14, you have to read rule 4. There is 2 exceptions. One is where the change may be what is termed as minor, or where the change is required in order to comply with a notice that is received from the planning authorities. So if the planning authorities have issued a notice to indicate that the pond or the jacuzzi or whatever it might be in the flat doesn't meet with the requirements of the statute, or there is some sort of a violation, and a notice is issued, and the promoter has to comply with that notice, he then obviously doesn't need the consent of the flat purchasers, but he's obligated to do it, in fact, by statute, being the MRTP Act or the Development Control Regulations. But if it is a change which is not directed by a statutory authority, then if the developer on his own wants to change, he needs the consent of 2/3 of the allottees if it is a common feature which is sought to be changed. And if he's changing the layout or the size of an individual flat, he needs that allottee's consent. And this again is something which in my mind hopefully will reduce a large amount of litigation on this particular point. The other aspect is that the agreement for sale has to be uploaded. And there is a model form agreement which has been provided as a guideline. Now, I will touch upon this a little later also. But the model form agreement is, in that it really is a guideline. It's not absolutely binding. It's not a statutorily prescribed form from which there can be no departure. The rules, Rule 10 and the explanatory note to the model form agreement make it clear that this is only a guideline and you can change it. The only thing that you need to ensure is that you comply with the requirements of section 13.2. And I'll come to this a little later, but you can only just note that the fact that the agreement that is going to be entered into with all the flat purchasers has to be uploaded on the website, again goes to show, goes to bring about the transparency that is required, that no flat purchaser then will say that, oh, how can I be asked to, it's there on the website, you can read it. There have been cases, in fact, I've appeared in some also, where the flat purchasers have actually challenged certain contractual terms, indicating that they were contrary to the provisions of the Act. Complaints have been filed by the authority and orders have been passed. One particular matter, in fact, the builder accepted that yes, certain clauses needed to be changed. They were changed, and the authority then directed that this amended form also should now be uploaded onto the Rera website. So this actually brings about an equaling of power, if I put it that way. It's not that, earlier you had no choice. Whatever the builder told you, this is the contract, you had to simply put your signature at the end. That's no longer the case. And gradually, as the consumers in that sense are becoming more educated and more aware, they now realize that they can actually take developers to the regulatory authority and correct these changes. So that is on, yes, so that's section 13.2. And so far as the agreement for sale being uploaded as well. The next, and what is most of the amount of litigation which is just now going on in the Rera authorities and in the appellate tribunal, really flows all from section 18. Section 18 talks essentially about in 18.1 it talks about where the developer has failed to provide the flat either as promised in the agreement or within the time as promised. It either then contemplates two situations where the flat purchaser has the right to choose whether he wishes to exit from the project and get his money back with interest, or in cases of delay, he can then choose to say, no, I wish to remain in the project, but the delay from the contractually agreed date up to the time I'm actually put in possession, the builder must pay me interest for. And under 18.3, they are entitled to compensation for any other breach of any rule or regulation under the Act. Now, in the celebrated judgment of Neil Kamal, that's 2017 SCC Online Bombay 9302, the Bombay High Court held that 18 was not retrospective in operation, but retroactive, which essentially means that it applied even to contracts which were entered into before the Rera Act was brought into force. And therefore, even in cases where the contract may have been under MOFA, the flat purchasers are entitled to come to the Rera authority and ask for compensation or ask for interest or refund of money under Section 18. Another interesting judgment in this is of Manjeet Singh Dhaliwal versus Manjeet Singh Dhaliwal. It's the 2018 Rera Appellate Tribunal judgment, where the developers took a defense that 18 would be applicable only if there was a duly signed and registered agreement for sale. And if it is only an allotment letter, they couldn't apply. That the appellate authority said no to, rightly, and they pointed out that even as long as there is a concluded contract and an allotment letter incorporates those terms, then they would be entitled under 18 to apply for either interest or refund. The other salient feature is under 19 of the Act. Under 19, basically, they say about quality control. They say that for up to 5 years after the flat purchaser has been put in possession, he can apply to the Rera authorities for compensation if there is defective workmanship. So this again brings about a situation where a person doesn't have to go and file a civil suit after he's put in possession and wait for a number of years. He can in fact come to the authority. Another interesting is section 15, where the authority has now indicated that a promoter cannot assign his obligations to and get another developer into the project. Sometimes promoters may find that they are incapable, or they may be delay, or they may even just be some malified intention, and they try and palm off the project to another developer, which then creates a whole series of complications. So under Rera now, they have made it clear that a developer cannot assign his obligations under the development agreement or the flat purchase agreement to another developer unless 2/3 of the allottees have agreed for the same. Just last 2 points on this, for the salient features. The real estate agents, now in section 9 and 10, this is something new, as I've indicated, is that now real estate agents also have to be registered, and there are prescribed duties and functions that registered agents have to do. I'll just come back to this, but you can only note the definition of who is a real estate agent is in section 2ZM, and the sections are section 9 and 10. And really what I think is the main feature or the salient feature of this whole act is the fact that now there is a regulator and there is an adjudicatory mechanism. This is in fact from sections 20 to 40 of the Rera Act. And this basically is, to my mind, the best aspect is that now there is a regulator to govern this industry, to ensure that there is compliance and people don't have to go running to the civil courts or even it be to the consumer forum and try and get some sort of compensation. There is now a person that you can go and actually complain to who has the means of correcting the agreements, who has the means of actually ensuring proper registration, compliances, how the money is to be kept, used for construction. And we now have got the Rera authority and the appellate tribunal in place, which was all started in 2017. Fortunately, I don't have all the details, but I can only tell you this much, that the Maharashtra Rera authority is by far the most active in that sense. Most of the cases are, in that sense, arising in that sense in Maharashtra. In fact, I can only point this out. This is there from the Maharera website, that approximately from 1st May 2017, there have been more than 10,000 complaints that have been filed. And I must say, it's quite impressive that more than 70% of those complaints have already been dealt with and disposed of in these last 3 years or so. So the authorities in that sense have functioned. I can tell you is that when the appellate tribunal had first started, in fact, appeals were literally coming up. I've seen appeals being done in 2 months, which was the prescribed period for the appeal. However, unfortunately, we know that there are only 3 members in the appellate tribunal. The Bombay High Court has ruled that for a bench to be constituted, you need 1 judicial member and 1 administrative or technical member. And therefore, it literally means now that 2 people have to sit and the 3rd person cannot sit. So though we have 3 members, it's effectively only one bench where one person is in that sense idle on some days of the week is now how they've worked it out. They need to get more people in. Appeals now are beginning, the backlog is beginning to pile up. It is taking a little bit more time, but the authorities are in that sense, really, they're just doing the best that they can. So this essentially is, and I'm not getting into the whole aspect of, there's a whole chapter then on offenses and penalties, etc. As I pointed out, those penalties are not small penalties. They're not, I mean, they are substantial penalties. And I've given you illustrations also where the penalties have been in the nature of 50 lakhs or 30 lakhs for non-compliance with registration, not disclosing the Rera address website. Now, if I can, I know that I'm running short of time, but let me first, and I was told that some of you all actually have this question about parallel proceedings, that Rera now being another forum, because section 88 of Rera says that this is an additional remedy. So can you go to the consumer forum? Can you go to Rera, IBC, suit? Can you do these things parallelly? So I was asked to address you all on this. Now, normal jurisprudence always tells us, whether it be a civil case or in criminal, you cannot have 2 proceedings for the same relief. Section 10 of the CPC discusses that, and principles of double jeopardy also are there under criminal jurisprudence. So you can't, in that sense, file different, you can't file in that sense 2 proceedings for the same relief in 2 different forums. That even Rera does not contemplate, that even Rera does not allow. 88 only says that Rera is an additional remedy, means you could choose to not go to the consumer courts and come to Rera. Now, I'll just quickly deal with it firstly, so far as the IBC is concerned. We all know that the IBC section for 7 was amended, and even flat purchasers now.
Naushad, your audio is not audible.
Sorry, is it better now?
There is some disturbance in the audio.
Can you all hear me now?
Yes, sir.
No.
Yeah, is this better?
Yes, we can hear now.
Yeah?
Yes, we can.
Hear now.
Yeah, okay. So far as the IBC is concerned, we all know that section 7 was amended, and now even
Now I request everyone to please mute your mic and video.
Yeah, so I hope it's clear. So section 7 of the IBC was amended, and even allottees now could apply under the IBC code for insolvency in that sense of developers who didn't pay money or didn't refund or didn't refund the money when the allottees in that sense decided to opt out. There is of course now the 2020 amendment also, which now says that it is only if 100 allottees decide to approach the IBC that they can have come under section 7. However, in Pioneer Urban, that's 2019, 8 SCC 416, the Supreme Court was also considering whether proceedings under Rera and IBC could go on parallelly. And they held that they can go on parallelly. But the reason for that is that the ultimate relief in both is different. And this is not something new. In the past also we've seen that you could have proceedings, say for under 138 for dishonor of a check and a summary suit maintainable. You could have winding up petitions and a summary suit essentially for the same claim. Bombay High Court, Supreme Court have held that they are all maintainable because the relief that you are claiming in the 2 are different. Insofar as the summary suit, or insofar as the summary suit is concerned, you are actually seeking a recovery of your money. Whereas in a winding up petition, you are not seeking recovery of your money. You are essentially seeking to wind up. One is, it becomes a judgment in rem. So that's the same thing even insofar as the IBC is concerned. That's the same principle which has been employed by Justice Nariman in the Supreme Court. and he therefore held that IVC and Rera can go on parallel. But now when we consider the consumer forum, the relief that you are seeking in both would be the same. If the relief is the same, then you cannot adopt both proceedings simultaneously. You have to elect. This, in fact, came up for just one other statutory provision is Section 71 of the Rera Act. 71 of the Rera Act actually contemplates that you can transfer a proceeding from the consumer court to the Rera authorities. It doesn't say that you can run both simultaneously, but you can transfer one. This came up for consideration before the National Commission in Ajay Nagpal's case, which is 2019 SCC Online NCDRC 335. This Ajay Nagpal's judgment came up for consideration very recently in the Delhi High Court. And the case is M3M versus Dinesh Sharma, which is reported in AIR 2020, Delhi 23, where the Delhi High Court also upheld the principle laid down in the Ajay Nagpal case and held that you cannot have simultaneous proceedings because you can't have two proceedings for the same relief, same issues. It may lead to a case where you may have inconsistent findings, and that's not, in that sense, in the interest of administration of justice. Even if you go onto the Rera website and you check out what their FAQs or that frequently asked questions, they also say and make it clear that parallel proceedings is not permissible between Rera and the consumer forum. You have to choose. I have also, in that sense, I mean, as a corollary to this, people have said, but is the relief different in both? Because under the consumer forum, I can ask for compensation, whereas under Rera, I am only going to be able to get my money back with interest. 18.3 is there in Rera, which also talks about compensation. So, of course, this is, I mean, I'm not getting into too much detail, but 18.3 is there. And frankly, what compensation would you be entitled to when it's a money claim? I understand that people talk about mental anguish or harassment, etc., etc. But that's something, again, which you would actually have to lead evidence for and prove. But otherwise, as long as you are getting your money back with interest, that normally amounts to sufficient restitution of whatever loss you may have had. Insofar as suits are concerned, it's important to note Section 79 of the Rera Act. Section 79 says that a civil court would have no jurisdiction to determine any question which otherwise falls before the regulatory authority or the adjudicating authority. So, so therefore, in my view, if there is something that is governed by Rera, which is to be decided by the authority or the adjudicating authority, these civil courts would not have jurisdiction in view of Section 79 of Rera. Having said that, there is a judgment in the case of Oberoi versus Ali Mistri. It's an appellate tribunal judgment in which they have actually said that a suit and the issue as to whether the relief really was the same. One was the use of a road and its layout, whether all that could have been in that sense gone into by Rera. But despite Rera ultimately holding that the two could go on, the appellate authority actually stayed itself and said that, but since this question is pending in the High Court, we will not proceed further with it. Now, I'm not sure as to whether that matter, in fact, has been taken higher or anything, but it's, I mean, the judgment doesn't really necessarily make too much sense, because if the authority felt that both could go on, why did it stay its own hands then? So that is an issue. But to my mind, Section 79 is a statutory mandate that the civil courts would not have jurisdiction to decide any question which otherwise comes under Rera. The next point, and unfortunately I just have to hurry up a little bit because of time constraints, but is really these online platforms. And this is something which is gaining some momentum really, and it's now coming up, and it still is pending, so I won't say too much about it. But online platforms such as Magic Bricks, 99 Acres, are they required to be registered as real estate agents? In India today, there are anywhere between, they say, 5 to 9 lakh real estate agents. It's a sector which was wholly unorganized. They were not responsible to anyone. They were not answerable to anyone. There were many complaints about misleading information given by them. Builders would say, oh, I never said it. Your agent has said it. Agents would say, I've never said it. And these flat purchasers were often caught between the two. This, in fact, Mr. Venugopal in his speech has criticized it, and hence held that the need for having even real estate agents being accountable and governed by the provisions of the Act. I'll just quickly tell you the provisions. Unfortunately, I don't have time to go through all of them. But Section 2ZM is the definition. Section 9 is the requirement of registration. And it says that unless you are not registered, you cannot operate. Section 10 are the functions of the real estate agent. 62 is the penalty. And then the rules. Rule 11 to 17 really, again, deal with the functions, how they have to apply for registration, renewal of registration, and the functions, again, of the real estate agents. Now, in this regard, insofar as when we normally think of a real estate agent, we normally imagine the person who comes with you, takes you, shows you the apartment, will maybe even negotiate on your behalf with the builder, will give you the documents, tell you what to do, maybe even come with you to the registering authority, ensure that the registration takes place. That is the classic definition. An interesting question is now pending before the appellate tribunal, wherein they have gone and the online platforms, such as, say, Magic Bricks is concerned, have gone and questioned as to how they can be classified as a real estate agent. Because what they say is, I am not actually taking anybody anywhere. I don't negotiate on their behalf. I am, in that sense, an intermediary. I am a platform whereby a person who wants to sell, or maybe who wants to sell his flat, comes and he uploads his details on my website. A person who looks, sees the property, and in that sense, on my website, the buyer meets the seller. The websites are not paid only if the transaction goes through. There is, in that sense, no further assistance that is given by the websites. The websites are not responsible in that sense for ensuring anything else. They may not even see the buyer. They'll never even meet the buyer. It is an intermediary who acts in that sense as a neutral platform. So the question then came out as to whether they were still required to be registered. There is a really well-written, and it's a long order passed by the authority, which essentially ultimately decides nothing. Inasmuch as they simply lay down principles, they consider definitions, but there is no ultimate direction also as to whether the various persons to whom notices were given were in fact real estate agents or not. The order simply says, if you are doing ABCD, then you get yourself registered. So it lays down some sort of guidelines, but doesn't ultimately pass any enforceable order. There's no actual direction. That, of course, still is being challenged, because the argument on one side was that when you see the definition is to be read not together but separately. So there are various subheads, and each subhead could even mean that it is a real estate agent. One of the subheads in the definition is a person who facilitates. So it literally means, therefore, and this is in fact what the authority noted, that results into something absurd. That tomorrow, if I know that there is if Mr. Murarka in that sense is say looking for a flat, and I say, oh, I know that Oberoi has got some flats available in the area that you're looking, does that make me a real estate agent? Because in that sense, I have facilitated. I have introduced the buyer and the seller, but I don't do anything else. So that is something which is really pending. And the difficulty which these platforms in that sense have expressed in the appeal is this, that if you see the functions that a real estate agent can or the function that the real estate agent is required to do, these platforms don't do it. But the minute you ask them to register themselves as a real estate agent under the Act, they then become statutorily obligated to do something that is not their business. And in fact, we had applied in for stay. We had argued this point before the appellate authority. We're still awaiting the judgment. And unfortunately, with this whole coronavirus and everything is now still in limbo. But hopefully this judgment should come out soon, and we'll have a little bit of better clarity on this. Now, just quickly then, the third aspect is maintainability of the complaint after the OC is obtained or taking possession. Now, there are two judgments. One is in Balaji Infinity, and the other one is Rekha Sinha versus L&T. In both these two decisions of the authority, they held that once the developer has obtained the OC, and complaint under 18 is no longer maintainable. The idea being, or the rationale of the authority was, that the whole object of Rera is that you must make sure that possession is ultimately being given to the flat purchaser. Once the developer is willing to give possession, then that's it. After that, you can't maintain a complaint. Rekha Sinha was then taken in appeal. In appeal, they held that no, 18 is not to be read in such a restricted manner. And in fact, even after a flat purchaser may have taken possession, he can still maintain a complaint. The decision of the appellate tribunal was carried to the Bombay High Court. Bombay High Court set aside the judgment not on merits, but only on the ground that the appellate tribunal comprised of only one member, and the requirement of the statute is 2, and on that ground has sent the matter back, and it is still pending. But to my mind, I do find it to be a little strange that a statute which is enacted to protect the interests of the flat purchaser would say that the minute the gentleman obtains an OC, you cannot sue him. If we, just to go back, if we see section 14.3, 14.3 says that even for 5 years after you are put in possession, you can sue the promoter if there is defective workmanship. 17.1 ultimately talks about the statutory obligation to convey the land in favor of the society or company or association which is ultimately formed. If this is not done, then obviously under 18.3, you can file a complaint and claim compensation. So to say that a complaint under 18 cannot lie the minute OC is obtained, to my mind, I don't think is correct. 18.1, there is two possible views. 18.1 obviously is the situation where they say that the promoter has not been able to put the flat purchaser in possession in accordance with the terms of the agreement or as per the date. Now, the argument on one side of the developers is that this obviously is a situation where the person has not been put in possession, or where the person obviously is not yet taken possession, which could only mean that I haven't obtained the OC. Because once the OC is obtained, then under 19, the flat purchaser is bound to take possession within a period of 2 months, if I'm not wrong. So they say that 18.1 can only apply in a situation where I have not offered possession. They say that the minute I have offered possession, then a complaint under 18.1 cannot lie, even if the possession is offered belatedly. They literally therefore expect that the flat purchaser must, the minute the date goes, then have to come rushing to the court and say that, look, date has gone, now you must file a section, I'm filing my section 18. That to my mind is not right. Even if the possession is offered, for example, there may be a situation where a developer is offering possession 2 years later. The person who then ultimately is relieved that albeit 2 years late, I'm getting possession. He says, okay, fine, put me in possession. And then he sues. he sues for that period of delay. I don't read section 18(1) in any such manner that would preclude the flat purchaser from filing that complaint after that, even if he has offered possession. The only exception where he could not do so is where, if, for example, and this is again it's a contested point, there is no finality to this, it is something which is pending consideration, is that if in a situation the developer offers possession and the developer tells you that I'm offering you possession in full and final, you are accepting this possession and you have no claim, and you agree to that, you have accepted this substituted performance, then under section 55 of the Contract Act, you cannot claim any compensation, even though it is a statutory right of yours, in that sense under 18(1), because you have accepted a substituted performance. It is only if you at that stage tell the developer or the promoter that I am accepting this, but I am going to claim compensation. If you have that caveat, you can, but if you don't, then you cannot. There is one judgment in the case of Sikotra, again of the appellate tribunal, where, of course, not in the detail I have set out, they have pointed out that the minute the OC is obtained, the flat purchaser's right is not taken away, and they can file an application under 18(1) as well. And it stands to reason, especially considering that this is an enactment which was made for the benefit of the flat purchasers. The preamble clearly states that one of its objectives in that sense is to protect the interest of the flat purchaser. In that scenario, the interpretation that would be given, in my view, to 18(1) has to be one which would favor the flat purchasers. The other point, again, which I've been asked is on investors. Can they file complaints? Because under consumer protection law, often when a defense that is taken and which succeeds also, is that this person is not a genuine flat purchaser. He's a mere investor. He was doing this for commercial gain. If he's doing it for commercial gain, he cannot be a consumer, and therefore the consumer complaint is not maintainable. There is a slight difference in the sense that under Rera, there were two judgments. One is of Sunil Dias versus Omkar, and Mahesh Paryani versus Monarch, in which Rera did initially hold that investors could not file a complaint in Rera. However, you can't just take that one line and say that that is the ratio, because you have to see the facts. In these cases, the agreements which were entered into was not a situation where there was a flat purchaser who was buying the flat only for the purpose of investment. Those were cases where the purchaser, in fact, was investing in the project and was really trying to share the profits with the promoter, and hence was held to be a co-promoter. This issue, because it had crept up a number of times, there in fact then was a circular that was issued on 4th December 2017, in which they clarified that what you have to see is the intention of the parties. If the intention of the party was to actually act as a co-promoter, he was lending money to the promoter to carry out the development work, so that ultimately they would share the profits, and profits could be shared either in cash, or the profit could be shared even by way of getting some amount of area, 1 flat, 2 flats, 3 flats. Then he would not be an allottee, but he would be considered to be a co-promoter. But otherwise, if that was not the intention, and this was just an individual who was acquiring the flat maybe for the purposes of further sale or for giving it out on leave and license, and was treating this asset as his as an investment, that does not mean that he cannot come under Rera. So that's an important distinction to be noted insofar as who can apply. And insofar as this aspect of the, can you change the model form agreement? As I pointed out, the model form agreement, which is annexed to Rera, has an explanatory note. First, read that explanatory note. To my mind, it makes it very clear that this is not it's not a It's not law in that sense. This is not a statutory mandate. This is only a guideline. It is capable of being modified. This also becomes clear from Rule 10.1 of Rera. And Rule 10.1 clearly says that you can modify, however, you must comply with Section 13.2. Now, Section 13.2 is important to note. So I'll just quickly highlight this. Under 13.2, what it says is, and I'm reading the section, the agreement for sale referred to in subsection 1 shall be, so it says shall be, in such form as may be prescribed, and shall specify then, one is, the particulars of development of the project, including the construction of building and apartments, along with the specifications and internal development work and external development work. So that's the first thing, that the particulars of the development of the project must be specified with the specifications of internal and external development. 2, the dates and the manner by which the payment toward the cost of the apartment, plot or building are to be paid over by the allottees. So therefore, the payment schedule again is something that must be there. 3, the date on which the possession of the apartment, plot or building is to be handed over. So this again is something which is critical, that the date on which the possession will be given must be mentioned. Some promoters have been avoiding to give that date and then try and avoid Section 18. That can't work. That date has to be there. And in fact, the authority should not actually even register such an agreement or accept it. They must indicate as to what is this date. It has to be there in each and every agreement. On the date on which, and fourth, of course, is the rates of interest payable by the promoter to the allottee and the allottee to the promoter in case of default. Earlier, we've seen many times that when the developers had to repay the monies to the flat purchasers, they would pay it back at 8%, 7%. And if the purchasers had defaulted, they were paying it, they had to pay interest at 24%, 21%. So that is done away with. All that now has to be clearly mentioned. So these are, in that sense, the statutory requirements that must be there in the agreement. Other than that, you can have certain changes. I noted that there is a question that was also raised as to whether earnest money can be deducted, because clause 18 of the model form agreement says that if the agreement is not entered into, then all the money must be returned to the allottee. This question came up in a case of Oberoi Construction versus Asset Auto. And the authority had held that the entire money must be returned. You're not entitled to deduct because Oberoi deducted the earnest money. In that case, I had appeared in it for Oberoi. There, it was a rather peculiar case. There was a case where the developer had filed 2 to 3 complaints against the allottee, because despite calling upon the allottee to sign the agreement, the allottee was refusing. The allottee objected to terms. Consent terms were entered into before the authority as to what were the terms he objected to. They were agreed upon. The agreement was directed to be put up on the Rera website. And despite all that, still the agreement was not entered into. And ultimately, the developer cancelled the agreement and deducted the earnest money. The flat purchaser obviously went to the authority and said, authority agreed with him and said that yes, under Section 18, it cannot be deducted. And under clause 18 of the model form agreement, it cannot be deducted. It must be paid over back to him. That was challenged in appeal. In appeal, we succeeded. And it was held that we were entitled to deduct that amount. We, in fact, even pointed out that it is not as if the model form agreement does not contemplate the deduction of some amount of damages or liquidated damages. Clause 4.2 of the model form agreement, in fact, contemplates it. And we had pointed out that earnest money deposit is something that has been recognized as when it is there in the allotment letter or the agreement, the party is aware that if for no fault of the builder, the party chooses to back out, the developer may, it's not that he has to, but he may deduct that amount. And the party is conscious and agrees to it. That is the very concept of an earnest money deposit. And there are judgments spanning back over about there are 3 or 4, I think one is Privy Council and then 2 Supreme Court on this very point and upholding the validity of such clauses. So earnest money deposits in my mind could be deducted. There is, in that sense, I don't think that clause 18 could be held to be part of the statutory framework. It's not there in 13.2. And of course, this is still an issue which is open. It is a hotly contested matter, and I mean, we have to ultimately see how the courts uphold it. It's very possible that the courts may, considering the objective of the act, hold that no, the amounts in fact have to be repaid. But yes, that's something which we'll just have to see. So I think I have overshot my time. So this basically concludes what I would say is my overview of the act. Thank you.
Okay, thank you so much, sir. Indeed, it was a very informative session for all of us, and we are looking forward to have so many sessions like this in future by you, sir. And I know that there are so many questions by the participants in chat box. So I'll request everyone that please stop circulating your questions. This we will be sending to Naushad sir after the lecture is over. We will retrieve all chats and we'll send him to him for his consideration. So thank you, sir. Thank you so much.
My pleasure. Thanks a lot. Thanks for everything. I also like to thank my juniors who helped me just collecting all these judgments. So thank you.
Thank you to them also, sir. Thank you. Thank you so much.
All right. Thank you.
Thank you. Really appreciate. Yeah.